Okay, hi. My name is Carol Crossett. I'm a partner at Tully Rinckey, really great place to work at. I focus my practice on corporate and commercial business transactions and litigation. I also do some estate planning as well. I represent a large, wide range of types of businesses, anywhere from industries to franchises and so forth, to small businesses and in between. I have experience handling contracts, different types of corporate transactions and different types of litigation related to companies. And that's what I do. I also do business succession. I don't do a lot of that, but I do a fair amount of it. Okay, so we're going to launch in. There is, as usual, I got a little bit too ambitious. And because of my ambition, we have a lot of material to go through. So I'm going to get cracking. I hope that I am able to complete everything that I wanted to discuss today. That's the agenda. If I don't, that's not I can always send any type of case law or anything that I discuss in connection with this presentation to those who want to do a little bit more reading. So we're going to go through, there's three essential parts. One part is the asset protection part. And asset protection involves the lawful use of mechanisms to legally and legitimately protect and insulate assets including from a creditor, subject to legal doctrines, subject to exceptions, but you can't seek them to avoid the claims of creditors, and we'll get into that, like fraudulent conveyances and transactions. We'll discuss that. We'll discuss different mechanisms, successful liability, piercing the corporate veil, alter ego. And you can't use it, you can use it to reduce tax, because sometimes it's in conjunction with business succession planning or estate planning, but you can't use it for purposes of tax evasion and avoidance, obviously. So the examples of legally protected vehicles, and these are not limited to the vehicles that I discuss, but I do discuss a couple of them because this is basically a survey of different legalities involved in asset protection and different attacks on the immunity and creditor protections. So 401ks are protected from the claims of creditors. Basically, ERISA provides protections to pensions and profit sharing plans, and we're on slide 5, I believe, to profit sharing plans, including 401ks. They are just basically if they're employer-sponsored plans. Now, IRAs are protected from creditors in bankruptcy, and they're also protected in New York law. It provides protection from creditors for individual IRAs and Roths because they're considered personal property that is exempt from money judgments, and that's CPLR 5205. If states have different laws related to IRAs and Roth IRAs, and some of them it's not exempt. So one possible means of would be to make contributions by rolling over qualified employer-sponsored plans that are protected, such as a 401k, into an IRA. But in order for them to remain protected in states there where IRAs are not normally protected, all of the contributions would have to be from a source that is otherwise exempt from, satisfying a money judgment under the state law, including but not limited to employer plans that are not. So it would have to be all of the contributions. You can't protect it for, if they're commingled. So the other device that's often used are limited liability companies. And even though they're not really asset protection, they limit liability. There's some overlap there in connection with what we're talking about. Trusts are also used. There's very many different types of trusts, and I'm not going to be able to talk about all of them. I am going to be able to talk about some of these principles using trusts. So we launch off, New York does not recognize self-settled spendthrift trusts. Some states do, New York doesn't. A self-settled spendthrift trust is a trust in which the grantor transfers the grantor's own property and assets to fund a trust, and it's set up in the name of the grantor as beneficiary. There's no protection because the trust is set up for the grantor's own benefit, and the trust assets are owned and controlled by the grantor who transferred them or who used them to fund the trust. So we looked at the state powers and trust law, section 7-3.1, which states a disposition in trust for the use of grantor is void with regard to currently existing or subsequent creditors of the grantor. And there's other provisions under that section, which we won't discuss, but that's the general gist. That's, the self-settlement and prohibition against it. So a transfer otherwise to a trust is only valid for purposes of protecting assets from creditors if a grantor doesn't reserve a power to revoke the trust, in other words, to get the trust assets back or dispose of property during the lifetime. And the concern there, one of the concerns is that you transfer assets to a trust and thereafter you terminate the trust or you revoke it. So that's a problem in terms of protecting the assets from creditors and whether they are or not. So some states recognize, like I said, self-settled spendthrift trusts, but it does not mean that they are not immune from attack. There are exceptions, including under the law, and there's many different exceptions and ways to attack it. But the Bankruptcy Code, as one, provides under 548 that there's a 10-year clawback provision for asset transfers to an asset protection trust, even in states that legally recognize the trust. And in some states, under their particular state fraudulent transfer act statutes, okay, or some other statute like in New York, even if there's no anticipation of liability that would lead to a judgment, by applying the full faith and credit clause to reach such assets. Another state, in other words, if you have a self-settled spendthrift trust or an asset protection trust that is valid in another state, but you transferred, say, New York property or some other property in another state in which they have a fraudulent transfer law not permitting the self-settled trust, there is a way to use that state law under statute or under public policy to obtain the assets from that trust. So although New York does not permit self-settled trusts, like I said, there's several different types of trusts that are permissible, and one of them is an irrevocable trust. There are also trusts called an intentionally defective grantor trust. And it's essentially a grantor trust, but it has a toggle that you can flip the switch to do different things. You can have a trust protector with specific powers. They can fire a trustee, replace a trustee, change the trustees, and change the beneficiaries, including determine when distributions are made, and they can even toggle it to name the grantor as a beneficiary. But this toggle cannot be used to avoid the claims of creditors that have not been satisfied. And that's kind of a general statement of it. There's more to it than that, but that's kind of the general proposition. Now, a revocable trust, and we talked about this already or hinted at it, there's no protection for assets that are transferred to it against creditors. Why? Because the grantor can revoke it at any time and remains in control, possession, and ownership, really, of the trust property. And the assets can revert back to the grantor. A creditor can also attack based upon establishing that there's actual constructive fraud. And we'll talk about that as well later on. So we're down to slide 8. So asset protection and Medicaid asset protection planning. We're going to go into this a little bit. There's a lot of detail here. So some asset protection will involve transfers for purposes of Medicaid planning and meeting the eligibility requirements of income resource limits that apply to receive Medicaid, and can involve many different forms, such as either a deed, transferring the property owned and providing the owner with a life estate interest, or doing the same, providing a life estate interest but transferring it to a trust. There's transfers such as gifts, and these transfers are related to Medicaid trusts or to irrevocable trusts. So the value of the reason for transferring, whether it's by deed or whether it's by transferring it to fund a trust, is to take it out of the ownership, possession, and control of the person who's going to be the recipient, the Medicaid recipient who wants to meet the eligibility requirements. And the life estate is not considered an asset for purposes of Medicaid eligibility, and it's not recoverable. So that's often the reason for doing that, to make sure that the applicant no longer has ownership or control. But there's also a 5-year look back period, and I could really go on to this. It could be a CLE in and of itself, related to transfers, and looking back to see what income and resources that owner had within the 5-year look back period that were owned or still owned or transferred. And if married, if there is 2 spouses and they are married and they're both going to be Medicaid recipients, it would include the applicant's spouse transfers ownership of property. So there are certain exemptions to this. If you have a primary residence and you have a spouse, obviously you can have the spouse live in the property, and that's not going to be a problem. But there are equity limits to it. The equity that is, ignored for purposes of primary residence is, in 2025, the equity of a primary residence is excluded from income if it's less than $1,097,000. So that increases over time because of the cost adjustments and so forth. But that is, I believe, that is the 2025. There are also exemptions too if a disabled child, somebody who's blind, needs the primary residence. And of course, the primary residence is not protected if over the equity limit. And both spouses are applying for Medicaid. So there's a difference between one person applying for Medicaid and the other spouse not, and then both spouses applying for Medicaid. Also, this goes into permanent absence from the home. So there is an argument to be made that if both spouses are going to seek Medicaid or are receiving Medicaid, and there's a permanent absence because they both required long-term nursing care, that could allow for a Medicaid lien to be imposed. Otherwise, the transfer of ownership to a spouse of a primary residence will not be considered for purposes of receiving Medicaid if that spouse is not applying for Medicaid and the spouse is going to live in the residence. And also there's other transfers that are allowed as well to provide income to the spouse up to a certain limit. And the reason for that obviously is the policy that, if one spouse is going to apply for Medicaid, you don't want to leave the other spouse impoverished for doing so. If one spouse will apply for Medicaid, the asset limitation is $32,396, and it is $157,920 for the other spouse who is a non-applicant. They're not applying, and the reason for that is that impoverishment rule. In order for not to be considered a Medicaid asset, for purposes of determining eligibility for nursing home Medicaid, property can be transferred to the trust, an irrevocable trust, for purposes of beneficiaries of the trust. And this often occurs with real property in which, when both spouses require the protection, or if there's one single person who does not have a spouse and they require the protection, and they want to be eligible to receive Medicaid. And again, the trust will provide that the settlor will live in the home, and there's a life estate. The ability of the settlor to reside in the home transferred to the trust is also important, because the settlor can direct a trustee to sell the property, but it has to be in exchange for new property. It can't just be sold, because if it is, then there's a period of ineligibility for Medicaid purposes. But if it is sold in exchange for new property, then obviously you have IRC's Section 121 exclusion, which applies to sales and exchanges, in which the amount of gain from the sale, if it's a single person, it's up to $250,000. If there's joint returns with spouses are married, there's a joint return filed, it's $500,000, excluded from gross income. If the irrevocable trust is a grantor trust, and the grantor pays the income taxes, and this becomes important too, because the individual tax rates are a much lower threshold, a much higher threshold to reach the highest tax bracket of 37%, whereas in trust they're not. So the difference is, to reach a federal tax bracket of 37% for individuals would require $626,350 in 2025 of income. But for trusts, it's much lower. It's $15,650 in 2025 in order to reach the federal tax rate of 37% for income taxed to trusts. So there's a big difference. If the trust is not a grantor trust, but the income is retained by the trust and is not distributed, then the trust would be taxed. If it is distributed, then it would pertain to, it would apply the bracket rates under the law to individuals, which in the most part would be lower. So limited liability companies, property can be transferred to an LLC. And if it is a single member LLC and the property was sold later, you'd have IRC 121 as well. And they can also obtain a life estate interest to live in the property. The LLCs are often used for limiting liability, but such protections do not extend in certain circumstances, which we'll discuss. And for example, and I did a couple of examples here. If property is transferred to an LLC and a claim arises in relation to that property, somebody trips and falls, for instance, or there's a claim against the company. Collection of any judgment, if there's liability found, would be against the company. And of course, the individual would not be personally liable unless there was a piercing of the corporate veil that was favorable, which would allow the court to set aside the company as if it's a sham and disregard it for purposes of finding personal liability for damages. And there's also some public policy exceptions depending on the claim. Most of these, and I'm not going to discuss them, so they're really in general broad brush. But in certain employment actions under the labor law, taxes and environmental claims, environmental hazards and so forth, and there's other statutes that apply that would allow personal liability to be imposed if you meet that requirement, that is, if you make that showing. So if the judgment, as compared to the company, if a judgment is against the individual in the individual capacity and not the company, and they have an LLC, any interest in the personal property that the individual owns can be attached to satisfy the judgment, but not company property. However, a lien in some cases can be attached against the company for purposes of satisfying a judgment in the event that there is a future distribution of cash or property from the LLC to the individual members. This would be in the form of a charging order, if you could get one. And it could mean that if there's distributions made, the charging order could be for the purposes of ordering and directing distributions to be made to satisfy that debt. And again, we go back to, successor liability, corporate piercing, and fraudulent transfers, which we'll discuss. in relation to getting a charging order. So the economic interests of an LLC member can remain open to attack, to obtain such a charging order. However, an LLC could not seek an order for assignment of an individual's membership interest, their management membership interest in the LLC, in order to say, for instance, vote on transferring an asset for purposes of, satisfying the judgment, or for purposes of entering into some sort of transaction and otherwise taking control of the LLC. That is prohibited. You can't do that. So you can't seek an assignment of the management interest of the members. It's just the economic interest that possibly remains open to attack. If you are worried about economic interest, there's certain provisions you can use in an operating agreement to try to, avoid that possibility in the event that a lawsuit is against a member. So whether, in addition, whether a loan from an LLC would be subject to a lien, since it is not a distribution, would obviously depend as well on the timing of the loan and the purpose of the loan. And there are instances where a loan is characterized as for the LLC or for its assets, when the loan is actually to a member, an individual member of the LLC, for their own personal benefit or for their own personal assets, and that would be subject to attack in that case if there was a judgment against an individual and they had such an interest and they engaged in recharacterization of transactions.
So the first course code is 184682. Again, that's 184682. And I'll leave it on the screen for a moment.
Fraudulent conveyances. We're going to discuss this under the Bankruptcy Code and other doctrines. This is going to include successor liability, piercing the corporate veil, and so forth. So first, we're going to talk about fraudulent conveyances kind of as a whole. Now, New York had a debtor and creditor law, and this pertained to allowing creditors to attack certain transfers and conveyances by alleging that they're constructively fraudulent or there is actual fraud. That was under the debtor and creditor law, and that applied up until April 3rd, 2020. For transfers after that date, starting on or after April 4th, 2020, it's under the new law, which is called exactly what I referred to before, the Uniform Voidable Transactions Act of New York. That replaced it. And you can look at the sections. They're in Article 10, and we're not going to be able to get through those, obviously, today, but we'll get through a couple of them because there's differences under that. First of all, the old law referred to fraudulent, and the new law refers to voidable. So that's often the titles that you'll see with respect to each section under Article 10. So DCL, we'll call it the debtor and creditor law, but it's under the UVTA, the new UVTA, applies to present creditors. That's 274. And it states a transfer made or obligation incurred by a debtor. And this is slide 12. I apologize. Thank you. Is voidable as to a creditor whose claim arose before the transfer was made. This is present creditors, or the obligation was incurred. So it's before the transfer was made or obligation was incurred if the debtor making that transfer or obligation was without receiving a reasonable equivalent in value in exchange for it, and the debtor was insolvent at the time, or the debtor became insolvent as a result of the transfer or obligation. And B is, very, very similar. It refers to, again, present creditors and insolvency. So it provides, in part, is A transfer made by a debtor is voidable as to a creditor whose claim arose before the transfer was made, if the transfer was made to an insider for an antecedent debt, and that means pre-existing debts or that you want to satisfy or settle. And then the insider is defined broadly, and that means almost anybody, family, relatives of any kind, directors, officers, those in control of the business, including affiliates and general partners. So insiders can also be an individual and a company. So the statute goes on, the debtor was insolvent at the time, and the insider had reasonable cause to believe that the debtor was insolvent. And the focus here is on both parties' knowledge of the transaction and the reason for the transaction, that there would be insolvency afterwards. Or insolvency was occurred before. And then under 273, that applies to present and future creditors. And it provides that under A, a transfer made or obligation incurred by a debtor is voidable as to a creditor, whether the creditor's claim arose before or after the transfer was made and the obligation was incurred. If that was incurred with actual intent to hinder, delay, or defraud any creditor of the debtor, or without receiving a reasonably equivalent value in exchange, and the debtor was engaged or about to engage in a transaction of some course that was would result in the debtor's assets that were remaining being unreasonably small. In other words, unreasonably small capital in relation to the business or transaction. In other words, afterwards, you can't pay your debt. Or with the intention to incur or believed or reasonably should have believed that the debtor would incur debts beyond the debtor's ability to pay as they became due. So we're not going to parse that out, but I think that, this is related to the actual actual intent, actual fraud mechanism, because the factors evidencing actual intent to defraud under the prior law, DCL, they did not have, the statute didn't identify badges of fraud. So we're going to slide 14 for that. The new law that applies, the UVTA, does identify badges of fraud. Before, they were decided based upon case law developments, but now that they have a list of them. And the first one is a transfer to an insider. The debtor retained possession or control of the asset post-transfer. It was disclosed or whether it was concealed. The debtor had been sued or threatened with a suit. The transfer was substantially all of the debtor's assets to get rid of them. Debtor absconded. Yeah, that's obvious. The debtor removed or concealed assets. The debtor received, whether they received a reasonably equivalent value for the asset transfer, and whether they were insolvent or they became insolvent, they were rendered insolvent by that transfer. Is important. And then the transfer occurred shortly before or shortly after the substantial debt was incurred. The debtor transferred the essential assets of the business to a liener, who then transfers the assets to an insider of the debtor. So that's another one. So these badges of fraud, there's no single factor. It's kind of dependent. It's very much in terms of the fraudulent conveyance and other of these doctrines that we're going to discuss. They represent factual issues in most cases, and in a lot of cases they cannot be disposed on. A motion for summary judgment. You just simply can't. The prior law, and this is important, the prior law had a more creditor-friendly 6-year statute of limitations. The new law is a look-back period of 4 years for constructively fraudulent transfers. Under the new law, UVTA, the transfers for purposes of showing actual fraud would be 4 years from the date of the transfer, or 1 year from the date of discovery of the transfer, whichever is later. And there's reasons for that. And we go through back to the badges of fraud, which, refer to concealment and so forth. And if there are other CPLR claims, they go under the statutes related to the CPLR. And you can, with respect to those particular claims, you can invoke the 2-year discovery statute of limitations if there was fraud. So sometimes they're coupled with tortious, interference or fraud, other fraud claims, including fraudulent misrepresentation. And there's also cases related to transfers to insiders where the statute is 1 year. We're not going to go into that because we don't have time, but that's under the UVTA. The standard of proof required, and the prior law applied a preponderance of the evidence standard for constructive fraud cases. But other than that, if they related to actual fraud, they were under a heightened standard of clear and convincing evidence for an actual intentional fraud case. The new law, it's preponderance of the evidence for both actual and constructive, and that's good. And we'll kind of, we'll look at a case later on and stuff where I thought that, I think that the court would have found actual fraud if the new law had applied. It didn't. They found constructive, but they couldn't find actual. And, just generally, if there's a judgment against an individual and that individual, and we're talking about different scenarios here only, for example purposes. If there's a transfer against, if there's a judgment against an individual and the individual made a transfer of personal assets to a company, such as an LLC, it can be a different type of company. We use LLCs in this presentation to make it simpler, or to transfer to an irrevocable trust without a sale for, say, fair market value or promissory note, or without consideration or expectation that they would receive consideration, without some sort of reason for doing it. This could leave open the possibility of a lawsuit by creditors, depending on the circumstances. And of course, they would, be asserting a lot of the things that we're going to discuss, including what we just went over with respect to the UVTA. If the company was liable for a judgment and the principal made a transfer of money or property from the company to render the company judgment proof, or with knowledge that the company was unable to satisfy its debts, or would be unable to satisfy the judgment once the transfer was made, that would be another instance giving rise to a claim for fraudulent conveyance. And again, the proof in a fraudulent conveyance, the proof is always going to be on the creditor. So these are just concepts. It doesn't mean that you are able to prevail on them. But if you seek an attachment, a levy, an execution, injunctions, liens, charging orders, of course, that requires a court proceeding. And another one is an LLC making distributions to its members during the period in which there is notice of an anticipated lawsuit, or at a time when it could not pay its liabilities and debts, or believe that, it would incur those debts very soon, pursuant to a transaction that is pending. There's different scenarios for that, but those can be attacked. It's going to be very factual and factual orientated. And the members receiving those assets, those transfers, they can also be subject to a lawsuit for the attachment to void those transfers, get an attachment or an execution or some sort of lien on them. And generally, with respect to a corporation, and there's many more scenarios, distributions to its shareholders, officers, and directors if made to avoid, creditors, or preferential transfers of insolvent corporations are not going to be entitled to good faith. Other causes related to actions by judgment creditors involve the concepts such as successor in interest to a predecessor, as the potential judgment debtor, by arguing it is a continuation of the same business. There could be a couple of exceptions, because the general rule related to successor liability is that a corporation that acquires the assets of another corporation is not liable for the pre-existing liabilities of the acquired corporation, but a de facto successor liability attack, such as de facto merger, fraudulently transferred accident, or the company is a sham, or the purchasing corporation was a mere continuation of the selling corporation, are attacks to allow the ability to assert successor liability. And that's usually used on the basis to expand the available assets. In a parent subsidiary context, for instance, it's often used because a parent may be outside the jurisdiction and they want to find the jurisdiction to bring the parent into a lawsuit against the successor by saying that really the successor acted as the agent, and really the parent was directing the transaction or contract that's the subject of the lawsuit, or involved that the subsidiary was taking the directions of the parent that resulted in the damages. So I cited to one case, and again, I didn't have time to cite to this case in the course, in the presentation material before you, because there was a lot of cases and I changed my mind about whether I was going to cite to this case or not. But if you want the case law after this presentation, I will give it to you and stuff. It's very convoluted, so I'm going to kind of skip around a little. But it involved a case involving successor liability, piercing the corporate veil, and fraudulent conveyance claims, as well as other claims as well. So the case had kind of a convoluted history, and it eventually was decided on appeal and was referred back to the court for various reasons. So this case was 47 East 31st Street versus Bridge Street Worldwide. And it was decided in the First Department. The Supreme Court involved a defendant, Bridge Street Worldwide, who had been sued by a defendant. The background to this is that 47 East owned property, Bridge, we'll call it BW, leased the units for a couple of years, and the building was receiving favorable tax abatements under the New York real property law, and that was very beneficial to the owner to receive those tax abatements, and of course the lease provided that they would comply with it. Well, it ends up that BW did not comply with it, and they were basically investigated for leasing out under less than 6 months and being basically a hotel. What happened is during the investigation, this was ultimately proven, and because it was it's the owner's property, the owner ended up having to pay $4.5 million and also had to pay the investigation costs in the amount of, I think it was like $275,000. So after paying these tax penalties and costs, they went after BW and they got a judgment. And then thereafter and stuff, they asserted against two companies that were involved in kind of an acquisition. BW had not been able to pay a loan, and there was going to be a foreclosure. And as part of the foreclosure plan, the acquirer, and they just call it the acquirer, entered into a foreclosure plan to allow Bridge Street to continue to do business. And 47 East, asserted successor liability to bring in that company and another company involved in it. And the court addressed the elements of successor liability, claiming de facto merger and a mere continuation claim. And they also addressed claims for fraudulent conveyance and piercing the corporate veil. 2019 proceeding was really based on East 47 trying to partially move for partial summary judgment, which was denied because of the factual issues, and also related to another defendant who had moved to dismiss some of the claims related to the amended complaint. But what's important for us is the analysis. The court recited the analysis of the general rule and then went on to explain what a de facto merger doctrine is, what a mere continuation doctrine is. So a de facto merger doctrine applies when the acquiring corporation has not purchased another corporation merely for the purpose of holding it as a subsidiary, but rather has effectively merged with the acquired corporation, and it is premised on the theory that a successor, if it should take on and carry on the predecessor's liabilities, because they're getting certain benefits from that. And that's just one of the, one of the policy rules behind that. A de facto merger, they explain some of the, elements, continuity of ownership, succession of ordinary business, and dissolution of the acquired corporation as soon as possible, and assumption of everything to allow that company to continue doing business uninterrupted. And there's a continuity of management. You have the shareholders are the same shareholders on the same company, the same personnel, physical location, assets, and general business operations. A continuity of ownership alone is not going to be sufficient. It's a necessary element, though, so it's an important element. But it will include whether the acquirer obtains the intangible assets, such as the goodwill, trademarks, patents, anything like that, royalties, customer lists, and of course, the right to use the corporation's name. It does not require that all these elements be satisfied. So the mere continuation was also asserted against a different company that was named as a defendant in the BW case. And we're going to discuss that later on, but with respect to piercing the corporate veil. So there was eventually a decision by the Supreme Court that arose in 2022 in which the court made certain errors and relied on the September 2019 proceeding, saying that it was the law of the case, and the appeals court said no, it wasn't, because no merits were decided at that point. But piercing the corporate veil, we're going to launch into that because that is part of the discussion. So slide 19. Other causes may involve an action by creditors against an individual, such as an owner, director, officer, or other person who operates the corporation, to pierce the corporate veil by arguing the corporation's a sham, and if the corporation cannot cover its liabilities. And the general rule is that a corporation exists independently of the owners, who are not personally obligated for, personally liable for its obligations. But piercing the corporate veil is an exception to the general rule, permitting in certain instances the imposition of personal liability on the owners for the obligations of the corporation. So Town Line Car Wash versus Dawn's Clean Machine Car Wash, which was a second department case in 2019. And I cited to Board of Managers of Colony. I can provide you those cases. Piercing the corporate veil is not an independent cause of action. Instead, it's an assertion of facts and circumstances to persuade the court to impose the corporate obligations on its owners to try to expand the available assets for a judgment or to pay off and satisfy a judgment. So piercing claims are claims against a corporation, its owners, shareholders, and it can involve claims against a parent company. And we kind of alluded to that related to jurisdictional and agency principles. So as you can see, these principles involve a lot of different types of law, including possible agency law, apparent authority, and so forth, actual authority. Failure to follow corporate formalities is not sufficient. Commingling of the company's funds with the business principal's personal funds, that's an element. Treating successor claims usually involve treating the corporation as the alter ego of a shareholder or director. It's just one of the theories, but it's often used. It's also often used also with different companies. that end up in transactions, such as the case with 47 East case. So we go back to 47 East case, and the alter ego theories of recovery is that basically the corporate veil standards and the applicable standards for showing alter ego, which is often combined, they're virtually identical under New York law, and I have case law for that proposition. But you know, the one thing that I think that I should emphasize, and I haven't emphasized it yet, is there is a very, very heavy burden to meet this, and it's really heavy. The standard's very high to pierce the corporate veil. So we go back to 47 East. The claims for piercing the corporate veil were based upon an alter ego theory that the owners exercised complete domination of the corporation in respect of the transaction related to the acquisition and so forth. And such domination was used to commit a fraud or wrong against the plaintiff, which resulted in plaintiff's damages or injury. That last part, used to commit a fraud or wrong, or used to commit some sort of perpetrate some sort of wrong or injustice, is very important, because just by reason of the fact that there was exercise of domination of a corporation is not sufficient. The courts are only going to set aside and disregard that corporation for purposes of piercing the corporate veil if it is necessary to prevent a fraud, or for purposes of achieving equity if there's some sort of wrongdoing or injustice. So in 47 East, there was, defendants filed further cross motions for summary judgment at some point in 2022 to dismiss the claims. And on appeal, the appellate court found that the Supreme Court had erred in holding defendants liable under the theory of alter ego, because there were no facts to support the claim that defendants issued a new loan to Bridgewater, and then what they did is they starved the corporation out without making adequate provision for contingent claims, and they rendered BW judgment proof by layering on new secured debt. The court said no, that's not true. They found the fraudulent conveyance claims failed for the similar reasons, and that's why they're often tied in. And the court found something that was, that's interesting but not surprising. The fact that the acquirer had purchased BW purchased the loan involving BW that was the subject of the foreclosure plan at 65% of its value merely reflected skepticism of the buyer and the seller regarding the ability to satisfy the loan by BW. And there was no evidence that they were doing that doing it for purposes of not providing reasonable consideration. There was an actual legitimate business, interest for doing that. And there was no evidence of having starved that corporation either, BW, because it was found that the defendant instead did the opposite. They injected cash for the purposes of allowing BW to pay down its debts to third parties, of which the acquirer had no stakehold in. It was completely different parties that they had debts with. And they also further capitalized BW so it could pay down loans, principal and interest and so forth. And thus they could not have benefited from that either, because those loans had nothing to do with them. So the successor liability did not stand either because of these the issues under the alter ego, and also because neither of the defendants acquired the assets of BW at the end. It was a transaction that was completely legitimate, or at least not shown to be otherwise. So I cited some other case law too that was interesting. One of them was Crossett versus Megan Holding LLC 2015 case, in which originally the court had properly, it was found on appeal. The appellate division said the Supreme Court properly pierced the corporate veil because there was evidence that the individual fraudulently set a rent for tenants for the apartment, and thereby requiring thereby resulting in their financial injury. And I won't go back into the background of that because it's too complex related to what the actual issue was. But that's what the court found. And they denied defendant's motion to re-argue. But the appellate division certified the following issue to the Court of Appeals. And the Court of Appeals held that questions of fact remained about whether the individual, the 99% owner, a shareholder of Megan LLC, through his domination of Megan, abused the corporate form to commit a wrong or fraud, causing injury to the tenant. And thus, the result was that the order of the appellate division was modified to the extent by remitting it back to the Supreme Court for further proceedings to make such findings. And this goes back to my proposition that I said earlier: a Pearson claim is not well suited on summary judgment. And I cite a case that's 2024 for that, which is Board of Managers of Colony at Hartsdale condominium for these propositions as well. With respect to Town Line, that's another instance too. Town Line had purchased a car wash, which was the Dawn Cleans Machine car wash. And Barry Brookstein was the sole shareholder of DKM. The court held originally that with respect to both parties' motions, tribal issues of fact existed as to whether Brookstein had actually exercised complete domination of DKM in the transaction and whether he abused the corporate form to commit a wrong or fraud. Now, in this instance, it's interesting because it goes to show you that, it's very heavy burden, because at the end of the day, Brookstein had also filed a motion, but he did not establish prima facie entitlement to judgment as a matter of law for him either. So there was too many factual issues. But despite that, it was undisputed that Brookstein dissolved DKM without making any reserves for contingent liabilities, despite the existence of the provision in the contract of sale between Town Line and DKM, providing that for any breach of warranty for a period of 7.5 years after the closing of the sale, DKM would indemnify Town Line, even though it indicated that DKM would not be able to fulfill that requirement. And there was an argument, of course, sufficient to raise a triable issue on both parties, but also with respect to Brookstein, and whether he did this to strip the corporation DKM of assets and leave DKM without sufficient funds to pay it off its contractual contingent liabilities in the event that there was a warranty claim.
So the next code is 884904. Again, that's 884904.
Okay, so we're wrapping up here. I have some slides on, chapter 7, 13, and 11, which I talk about, and chapter 15. But I'm going to kind of go into, rather than discussing, the law related to that, because it's just too much and we're running out of time. I'm very sorry. Blame it on my ambition. I'm going to talk about 2 instances of cases that, I think that are very, very interesting. And we'll skip around a little bit. If you need more detail related to the slides, you can certainly ask me. But I think the slides speak for themselves. But I want to touch on 2 things before we go to chapter 15. One of them is estate planning. Is it a viable defense in relation to, possible fraudulent conveyances? And we're going to slide 25 for that. So I just want to give one example of a case. It involved an adversary proceeding. U.S. Bankruptcy sought to recover several transfers made before, during, and after a lawsuit against a debtor. The debtor had been found, there was a final judgment issued against the debtor. So after that, the debtor made several, after a lawsuit was filed and during that lawsuit, and then after the judgment, the debtor made several transfers for no consideration. Transfer of property he owned before he was married, that he solely owned. Prior to the marriage, transfers of stock interests, transfer of proceeds in accounts. He sold various assets. He transferred funds to an adult child and also to the college, but it did not meet the exemption under the college fund exemption under CPLR 5205. And on another interesting note, the debtor also sold equipment and inventory related to a company that it owned. And the sale went like this. The sale was made to a company A, who thereafter sold the equipment to another company B, in which the debtor's irrevocable trust held an interest in that company B. On the same date as the sale to A, and before the transfer to B, or around that time, another company C was formed by the debtor, which was owned by company B, which again, the irrevocable trust has an interest in company B. The debtor sold some additional assets to that of his company to company C, thereby stripping everything through a variety of transactions. And what the court addressed in finding that there was constructive fraud was that this property, the transfers, all of this took place. The debtor had argued that there was estate planning. And the court noted that despite this argument, there was no evidence. But even so, the way the transfers took place obviously gave rise to an issue of constructive fraud, because although he claimed he was doing estate planning because he had an illness that had developed, and the illness was real. He really did have an illness. The court noted that, he had the notice of this illness a couple years beforehand, and yet he didn't start making those transfers until one of them, particularly related to the property, was 1 week before the suit. Others were 2 months before the lawsuit. He was aware that his business partner was going to sue him. And then these transactions occurred, of course, during the lawsuit and after judgment. So the court found constructive fraud and related to the transfers. So at that point and stuff, the court awarded the trustee a money judgment related to transfers, values of which were readily ascertainable, and decided to do something related to the property because property is unique and its value is not readily ascertainable usually. But I suspect that the court would have found that the trustee would have prevailed also on actual fraud, probably, if the burden had been preponderance of the evidence for transfers occurring on or after April 4th, 2020. They occurred before, so the prior law applied, and they applied clear and convincing evidence. And then we're going to go to chapter 15 related to that. And I was going to say something related to a transfer of offshore companies, and I'll do that very quickly. But transfers of offshore companies, sometimes you see people, they are selling, if you make this transfer to an offshore island, the creditors can't get it. But that really depends. And again, the bankruptcy court provides substantial powers to a trustee. And there have been cases, and I was going to cite to one in which it involved a debtor. He was a director of a company, a U.S. company. He stole U.S. funds from different accounts, and then he thereby purchased an asset, a very valuable asset. And what he did is he formed, I think it was a company. I don't remember whether it was a corporation or what it was, but he formed it offshore, and he placed the asset to fund that company. He transferred it to fund the company, and the company now owned the asset, the offshore company. The gist of it is that, he was found to have engaged in all of these fraudulent conveyances in order to hinder the trustee's ability to, obtain the recovery of these assets as well as other creditors, because the company that he stole from went out of business as a result of it. It was stripped. It could no longer meet his debts. So he was sued by the company, and obviously there was a bankruptcy case associated with the company itself. At the end of the day, the trustee was awarded and the ability to take the lien on the asset initially, and then afterwards, the court also awarded the trustee the ability to hire the proper people in the offshore islands, whoever he was dealing with, and obtain, the cost and authority to do same in order to seize that asset and sell it for purposes of recovery. So I kind of wanted to say that. In terms of Chapter 15, that relates to, it's a framework, and we're on slide 26. It relates to cross-border bankruptcies. These deal with foreign companies in which they have an establishment, offshore, which is maybe a non-main proceeding, because there's two types of proceedings that can be commenced, and then a main proceeding, which, that can be commenced by the foreign representative. And the whole purpose of it is to file a petition, meet the applicable requirements, and then, of course, an automatic stay would stay the collection of creditors in the U.S. from proceeding, including any lawsuit from U.S. creditors. To the extent that they named the company before the petition was filed, and that there was either a lawsuit or some sort of claim related to it. So it stays ongoing lawsuits. So the gist of this is if you meet the proper requirements, and of course every nation has different requirements related to its insolvency and adjustment of debt. But the bankruptcy code provides that a foreign proceeding is a collective judicial or administrative proceeding. It's in a non-U.S. Country. They call it a foreign country under the bankruptcy code. It's under a law related to insolvency or adjustment of debt. And the debtor's affairs, the assets and so forth in which the proceeding relates to are subject to control or supervision by a foreign court, because in some proceedings, foreign proceedings, they have nothing to do with a court proceeding like we think of in bankruptcy. There's no petition filed, but there are, of course, certain relief, certain appeal rights and so forth, that in which a court would oversee it if there's an issue brought to them, but it doesn't necessarily have to take place in the court. So if it relates to that adjustment of debt and insolvency, and that creditor, U.S. creditor, files a claim and submits a claim in the foreign proceeding, the non-U.S. proceeding, and so and the administrators in that foreign proceeding decide that that claim has not been proven. It's like a contingent liability, such as a lawsuit about whether a person breached a contract or committed some sort of tort liability in the U.S. If that debt, if that claim for that debt and stuff is denied, what the foreign representative can do before they close the Chapter 15, when the insolvency and adjustment of debt foreign proceeding is closed over in the non-U.S. company, is before closing the Chapter 15, they can seek different types of relief. And they have other relief as well that they can do, but we're not going to have time for that. This one is important in the fact that in terms of the U.S. lawsuit, the foreign representative can file a motion and requesting that the bankruptcy court honor the determination and adjudication of the debt of the claim of the creditor in the non-U.S. proceeding. And if the court grants that and recognizes the determination in the non-U.S. proceeding against that creditor, denying the creditor's claim for lack of showing, then what would happen is it would preclude that creditor from proceeding any further with its separate lawsuit against that company that was the subject of the Chapter 15 proceeding, and thereby it would be dismissed. And it would dismiss the creditor's action against that foreign debtor. There's a lot of tie-ins to this, and it's really dependent, including upon the particular order and factual scenario, but that can be achieved. So I wanted to thank everybody. Of course, I went over time like I normally do. But if you have any questions, or you want the case law that I cited to, or you're interested in the question, or you have like certain cases that you want to discuss, you can call Tully Rinckey, and we can discuss about it. We can go further with it. I will be, certainly available to it. I'm sorry I couldn't answer any questions today because we're way behind time, but I appreciate your patience. I hope, I had to go through this really quickly, and there was a lot to digest, and some things I had to skip over, but I do appreciate your attention, and I hope you got something out of it, truly. I wish you well. Take care.
Thank you, everyone. And thank you, everyone, again for joining today's presentation. And thank you again, Carol. Please make sure that you complete and return your course evaluation and affirmation to CLE at tullylegal.com within the first 2 weeks of receive the certificate of attendance. I also just want to note that we are also promoting Tully Rinckey's Year of the Employee. We offer a competitive compensation with first-year associate-based compensation starting at $110,000 plus bonuses. We're offering a generous 401k match, and we have free health and vision, dental, and life insurance, 25 days of paid time off per year, flexible working arrangements, partnership, and long-term growth opportunities within our firm. If you are interested, please contact us at hiring@tullylegal.com. Other than that, if anybody has any questions or need any course evaluations or affirmations, please send an email to CLE@tullylegal.com. Thank you, everyone, and have a great day.